Hi everyone, I'm Mark Taylor from Chartergate Legal Services and I'm here with my co-founder Matt Boddington, and we are going to be producing a series of video resources for our client base looking at the joint and several liability tax reforms. This first video is going to be an overview of the legislation as a whole. So after you've gone through this video, it's really important you go back to the other videos and go through them to understand the detail.
So in this first video, Mark, we're going to be looking at the joint and several liability legislation coming into force in April 2026.
Yep, that's right.
So do you want to go through the basics?
Yeah, okay. So I think it's probably worth starting with how we've ended up where we are. So for a number of years now, HMRC have suggested there's significant non-compliance in the marketplace, whether that's via umbrella companies, employment businesses, labour supply intermediaries.
Yeah.
So they've looked at ways on how to legislate to target against that.
Okay.
Whether it be mini umbrellas, false self-employment, umbrella companies going bust and not paying the PAYE liability, they've tried to find ways to target that. And they've landed on joint and several liability.
Okay.
Which is essentially, I think, a recognition that while it might be the umbrella company that is the non-compliant business, because they are the business that hasn't necessarily paid the PAYE or has calculated the PAYE incorrectly, it's a recognition that sometimes the non-compliance can start further up the chain, because it may be the end clients at the top of the chain, or sometimes the employment businesses before the umbrella companies in the chain that are driving the non-compliance, or aren't doing enough due diligence to make sure there's compliance in the chain. So that's why we've ended up in a scenario where we have joint and several liability. It's a recognition that someone further up the chain, other than the umbrella company, should be liable for the PAYE in scenarios where it's not been paid over to HMRC correctly.
Okay, so how exactly is this going to work?
Okay, so I think if we look at the legislation broadly in two parts. So I think you've got part one, which I'm calling the protective element. So that is where all the parties in the chain agree that PAYE should be operated. And it's simply a case that either the PAYE has not been paid or the wrong amount of PAYE has been calculated.
Okay.
So it's essentially HMRC protecting PAYE that is already due.
Okay.
And I think there's a second part to the legislation, a significantly more complex part that I'm calling the proactive element of the legislation.
Okay.
And that is where there are contractual chains where PAYE isn't necessarily accepted by the parties as being the appropriate tax mechanism. So, for example, self-employed subcontractors or personal service companies where IR35 would apply. And this is where HMRC are using the joint and several liability legislation proactively to take those supply chains that are otherwise outside of PAYE and try to bring them within the PAYE regime. So significantly more wide-ranging, and something that requires a whole video in and of itself.
Okay, so going back to the basic joint and several liability for umbrella companies, how in detail is that going to operate?
Okay, so first of all, you need certain facets to be in play. So there needs to be an umbrella company. And it's important, I think, that everyone understands that we need to move away from colloquialisms. This isn't just, I understand this company's operating as an umbrella company, or they don't call themselves an umbrella company, so they're not within the legislation. This is about a specific legal definition. And the definition of an umbrella company revolves around there being an individual that is being supplied to someone else in the supply chain by a third party, and that individual is employed by the third party.
So it doesn't matter if they call themselves an umbrella company or a PEO or an intermediary or a commercial contractor, all of these terms that we hear quite commonly, they just have to meet that definition.
Correct. And this can apply to, for example, an employment business that wouldn't ordinarily call themselves an umbrella company or be behaving like an umbrella company. But if they are employing the individual, so under a contract of employment or contract of apprenticeship, then that will be enough for them to fall into this definition.
Okay, so even an agency could be an umbrella company as defined in the legislation.
Absolutely. even an agency that is employing an individual and supplying them to someone else further up the supply chain can fall within these terms. And I think that's the first thing people need to understand about this.
Okay. Yeah, that's important.
So then after that, we have a scenario where we've got, let's say, a three-party supply chain. So let's say we've got end client, umbrella company, employee at the bottom.
Okay.
So in that supply chain, what the legislation says is that where there is PAYE due and it's not been paid, the umbrella company is one of the liable parties, but then the party that they have the contract with is also a liable party. So in this three-tier chain, it will be the end client because they have the contract directly with the umbrella company.
Okay.
And for the legislation's purposes, the end client is called the relevant party.
Right.
So if we extrapolate that out to a longer supply chain, so let's say we've got end client, employment business, umbrella company, employee. In that scenario, the legislation says that the relevant party is the employment business.
Right.
Because they are the party that has the contract with the client. So in that scenario, the umbrella company and the employment business will be the joint and several liable parties for any PAYE that hasn't been paid or PAYE that's been calculated incorrectly.
Okay. And one question, when you mentioned employment, does that mean PAYE, or is there a particular definition of employment?
So
Legislation?
the way the legislation works is it's got to be employment in the wider sense. So it can't be because a different part of legislation deems them to be PAYE.
Okay.
It's got to be employed. So we're talking about a contract of employment, or we're talking about a contract of apprenticeship, that sort of contract. So if an individual is an agency worker,
Yeah.
and these definitions are important, if they only qualify as an agency worker or they only qualify as a worker for employment rights purposes, not employees, then this legislation won't apply to them.
Okay.
So I just want to talk about one more contractual chain because I think it's really important that people understand who the relevant party is. So we need to make the chain a little bit longer and a little bit more complicated.
Yeah.
So let's say we've got end client, employment business,
Yeah.
a tier 2 agency,
Okay.
umbrella company, and then an employed individual at the end of the chain.
Yeah, which is not an uncommon supply chain.
It's not uncommon, and it's really important that everyone in the chain understands where the liability sits here.
Okay.
So if there is PAYE owed, so unpaid PAYE, or there's been a miscalculation of PAYE, the relevant parties for joint and several liability purposes in that situation will be the umbrella company that's responsible for paying the employee, and then it will be the party that is closest to the end client. Okay. So in that scenario, it's the employment business that has the contract with the end client, so they will be the liable party. So for the employment business, in that scenario, there is, two other businesses removed from the individual, their visibility of what's going on in their supply chain will be really, really important.
Yeah.
Because they now need to know that what's happening below them in the supply chain is actually happening correctly and as they've been led to believe, because they are the liable party along with the umbrella company.
Yeah. So
the tier 2 agency has no liability in that situation.
Okay. Yeah, understood. So Mark, I just want to pick up on a point that you made earlier about the worker having to be employed by the umbrella company. Is there a particular definition of employment for this legislation?
There is, and this is really important because this is legislation that's introducing new concepts, new definitions, and it's really important everyone understands where their particular supply chain and engagements fall. So when we're talking about employment, we mean employed in the wider sense. So we don't mean an individual's employed because they're deemed employed under a different legislative provision. So for example, just being deemed employed for Section 44 purposes isn't enough. We're talking about a contract of service, otherwise known as a contract of employment, or something similar. So the reality is agency workers that are actually engaged as agency workers won't fall within the joint and several liability legislation, and workers, which is an employment definition, but workers, as we know them, or as we commonly refer to them, Limb B workers, they won't fall within the JSL legislation either. So it's really important that wherever you are in the supply chain, you understand how that individual is engaged at the bottom of the supply chain.
Okay. And if an agency worker were, say, to bring a claim that they were an employee of the agency and succeed, does that potentially give a route for HMRC to apply joint and several liability?
Potentially, but the reality is that the employment and the tax jurisdictions are separate. So simply having an employment tribunal decision, and remember, employment tribunal decisions are first instance, so they're not binding and they don't have significant precedents. So simply having that decision won't automatically make an agency worker for tax purposes qualify as an employee.
Okay.
But it certainly might get HMRC's gaze, and it might be the reason for them starting an inquiry and arguing that the individual's an employee.
Okay.
It may also, and I won't go into the detail here, it may also open the door to the purported umbrella company rules, but we're going to talk about them in another video.
Okay. Okay. And in terms of joint and several liability, what does that actually mean in real terms? Does it mean if the umbrella company doesn't pay its bill, the agency or the client has to pick up the bill, or is it deeper than that?
Well, there's definitely more to it, but in a summary, yeah, what we're talking about with joint and several liability is scenarios where there is PAYE due that's not been paid, and that could be a scenario where it's all been calculated correctly, and for whatever reason, the umbrella company simply doesn't pay it. The most common and probably the biggest risk for parties further up the chain in that scenario is business failure.
Okay, yeah.
But it also applies to scenarios where the PAYE hasn't been calculated correctly.
Okay.
So everyone accepts PAYE is due. PAYE is being paid on time to HMRC, but there are a few scenarios in which the PAYE hasn't necessarily been calculated correctly. Some common ones, for example, is where the umbrella company is operating expenses,
Right.
Paying those legitimately to the individual free of tax and national insurance. But if they are operating the expense rules wrongly, then some of those sums or all of those sums should have been liable for PAYE. And while that might seem in 1 week a small amount of money, if that happens for a long time and for a number of individuals, and HMRC are able to argue that the expenses should have been treated as PAYE, then that's a larger bill that not just the umbrella company, but the joint and several liable party further up the chain is liable for as well.
Okay.
Another example is where agencies commonly, when they're finding work for an individual, they'll tell them the hourly rate, and they might say the hourly rate for this is £20 an hour. But they don't actually clarify to the individual that if the individual is engaged via an umbrella company, the £20 an hour is the fee to the umbrella company.
Right.
Is the payment to the umbrella company.
Yeah.
And we see this a lot in employment tribunals, where there's a WhatsApp message or an email that says to the individual from the agency that says it's £20 an hour. And then the individual goes to the tribunal and says that £20 an hour should have been mine. But it wasn't, because by the time it had gone through the umbrella company, I was actually earning £15 an hour. And tribunals are fairly receptive to that sort of evidence. And that is something that HMRC will look at now as well.
Okay.
And again, on the face of it, it seems like quite a small amount of money. But if you've got, let's say, 100 umbrella employees, and HMRC are able to show that the hourly rate was something higher than they were actually paid, PAYE becomes due on all of that additional sum, at which point the joint and several liable party is jointly and severally liable.
Okay, so it's not just non-payment, it's any technical failure of the umbrella company is now potentially a liability of either the agency or the client,
Yeah,
as the case may be.
absolutely. And let me throw one more spanner in the works when we're talking about that. As I mentioned, things like the hourly rate, the individual being paid the wrong hourly rate, or another common claim is they claim that the umbrella's margin was part of their pay. All of those at the moment are individual tribunal claims. So, the chances of them coming up might seem remote. But from April 2026, we're going to have the Fair Work Agency, and they're going to have the ability to start a claim on behalf of numerous individuals all in one go.
Right.
So let's say that we have one individual that makes an employment tribunal claim right now.
Yeah.
That claim is isolated. From April 2026, where they go to the Fair Work Agency, they might say the £20 an hour should have been mine, but I was only getting 15 because of the umbrella company. The Fair Work Agency has the ability to look at all the workers. So if they think that one person has a claim, they can extrapolate that out to all the other workers and see if they've got a claim as well.
Okay.
At which point, the route for HMRC to say, actually, we think you've got the hourly rate wrong, we think there's PAYE due, is significantly easier for them. At which point, the joint and several liable party is liable for that PAYE as well.
Okay, Mark, so what are the key points that we've covered in this video?
Yeah, let's have a summary, if you like. So it's new legislation. It brings a new concept to PAYE legislation in the sense of joint and several liability. And I think probably the biggest key point is parties need to understand their contractual chain and how the individual is engaged in that contractual chain. Because as we've said, part one, the protective element, only applies to employees. So agency workers, other types of workers, if they're not employed, they won't fall within it. And then the other key point, I suppose, is when you're looking at the contractual chain, you've got to understand where you are in it, but also, are you the relevant party? So because it is the relevant party that will be the jointly and severally liable party if the umbrella company, for some reason, doesn't pay PAYE to HMRC or fails to calculate the PAYE correctly.